Welcome to the Bonavero Institute and also to our very first Litigating Rights lecture. My name is Anneli Mikus. I'm the head of programs of the Bonavero Institute. And we're delighted to have Wolfgang Kaleck and Ben Wizner with us as our first renowned litigators in this new series. And in this series, we plan to invite legal practitioners who have litigated human rights cases in different jurisdictions, in national courts, but also supranational courts, and to explore in this conversation a range of questions relating to the role and value of litigation in the promotion of human rights. Wolfgang Kaleck is a leading German lawyer and distinguished human rights activist. For more than 2 decades, he has been involved in the global struggle to hold powerful people and governments accountable for human rights abuses, fighting alongside those suffering injustice at the hands of powerful perpetrators who too often enjoy impunity. Just this month, Wolfgang was awarded the 2019 Basuni Justice Award for his leadership in the discourses and practice on double standards, strategic human rights litigation, universal jurisdiction, and capacity sharing. Wolfgang is the founder of the European Centre for Constitutional and Human Rights, ECCHR, an organization that has prepared numerous important legal actions against politicians, military leaders, and corporations for crimes against humanity. And I must say that it is also a special pleasure for me personally to welcome you to Oxford, Wolfgang, having met you 11 years ago and still having one of the very first flyers of ECCHR at home, and then also working with ECCHR in Berlin for 4 years myself. So welcome, Wolfgang. And Ben Wizner is the director of the Speech, Privacy and Technology Project of the American Civil Liberties Union. For nearly 2 decades, he has worked at the intersection of civil liberties and national security, litigating numerous cases involving airport security policies, government watch lists, surveillance practices, targeted killing, and torture. He appears regularly in global media and has testified before Congress and is also an adjunct professor at New York University School of Law. Since July 2013, he has been the principal legal advisor to NSA whistleblower Edward Snowden. And now to tonight's agenda. So Wolfgang Kaleck will open the evening with a reading from his new book, Law versus Power, and I will then moderate a conversation between Wolfgang and Ben, followed by an open Q&A, and then afterwards we all invite you for a drinks reception outside. But first, Law versus Power. The floor is yours.
Yeah, thank you very much, Annelien, and also big thanks to Bonavero, where we are going to have a very interesting workshop, more on the techniques and the methodology and politics of litigation tomorrow. And so the idea was Annelien and Kate chose some parts of the book and asked me to read a little bit. But before I do that, I just want to say a couple of words, because it cost me quite a lot to write a book in the first person. First of all, it's uncommon in Germany as a lawyer. There is a different culture, and it's in a way exposing yourself to a certain critique, and the critique is like, doing all of this only because to get more public attention, something which is like very common in London or in New York and even in other parts of the world. But in German, lawyering is a very discreet and serious thing. And if you go out and look for the public, you're becoming an unserious person. You're not taken serious. But I thought, and I was encouraged by a number of people, that it makes sense, not only because of my personal history, but this history coincides a little bit with the rise of transnational human rights litigation, because actually I started in 1998. So we started with the Argentina cases, and I come back to that in 1998. And then the Pinochet was arrested in October 98. And then I went through the ups and downs of universal jurisdiction and the expectation on the International Criminal Court, and also now the ups and downs with business and human rights litigation, and recently also migration litigation. And so that's the one thing, the one layer which I consider as extremely interesting. And the other layer is also very clear. In a time where people are not reluctant to declare human rights and human rights litigation for death, I want to remind of a time, a little bit over 20 years ago, where this kind of litigation wasn't even established. And so the first chapter I'm talking about, Guatemala, shows that, because it shows also the way of let's say, more or less normal progressive leftist lawyer into this transnational litigation field. But at the time, I make my first experience, that was actually in 1919 in Mexico and in Guatemala. There was no thinking about litigating against perpetrators of gross human rights violations. So this is the first chapter. When I arrived in Mexico, Guatemala had been suffering for 35 years under more or less openly military rule. In the early 80s, the dictators pursued a US-backed counterinsurgency policy of scorched earth tactics to rupture civilian support for the leftist guerrilla who had been fighting the state for decades. The consequences were devastating. In a few years, more than 100,000 people were murdered. Around 1 million more, mostly from the indigenous populations, were forced to flee, and more than 400 villages were razed to the ground. As I write this, I'm debating with myself as to whether I should set out those horrors in detail. It might help to make a lot of things clearer, but then the portrayal and the observation of the suffering of others brings its own conflicts. In her essay on photography, Susan Sontag asked the important question, I quote, "What to do with the feelings that have been aroused, the knowledge that has been communicated? Do they not lead to boredom, cynicism, and apathy? I also see a danger that we, those of us who work on these issues, only inflate our own importance with dramatic portrayals as though our own significance rises with the scales of the horror we report. Aren't we then appropriating the stories from those who have suffered in order to further our own work, even if that work has the best intentions? I choose to follow Sontag's suggestions and reflect on, quote, how our privileges are located in the same map as their suffering and may be linked to their suffering, as the wealth of some may imply the destitution of others, end of quote. Politically, it would be wrong to look at the question of human rights violation from a Western paternalistic point of view, isolated from their political and economic causes in the global capitalist system. I have to say that that's something I write now in retrospective. While I was in Guatemala, there was no thought of something like that. There was definitely not this level of reflection. All my colleagues at the Commission, I worked at the Exiled Commission of Human Rights of Guatemala, who had to work from Mexico. All of my colleagues were forced to flee Guatemala. The longer I work with them, the more I learn about their past. I hear stories about their own education, careers, and entire lives were appended due to the threat posed by the military. On November 1st, we celebrate El Día de los Muertos, the Day of the Dead. Like millions of people in Mexico and across Central America, my colleagues set up an ofrenda, a kind of altar, with pictures of the dead and colorful offerings like flowers, wreath, ribbons, and figurines. Many of the faces in the photos are very young, and each picture tells a story of violence and pain, of torture and murder, and relatives, comrades, or colleagues. In my third week, the head of the commission, Ana Antonia Reyes, a spirited woman in her early 30s, comes to me with an idea. Since '88, around 50,000 indigenous women who lost their husbands to state repression, have joined forces under a national association called CONAVIGUA. These women face discrimination in various kinds, as part of the rural class, because of their ethnic background, as women, and as widows. Ana Antonia suggests that I write a report on this young organization and travel to Guatemala to witness the celebrations around the 2-year anniversary of its establishment. As a German, it will be safe for me to travel, she says. We start making inquiries in Guatemala. It dawns on me that I'm secretly hoping it won't work out. I'm overwhelmed by the prospect of this trip. My Spanish is only passable by that time, and I'm glad to have somewhat settled into life in Mexico City. In this moloch of a city, I found people whom I like and who like me. I found places I'm fond of, the markets and the cantinas at night, as well as the music. When I look back in early 2015, when I write this book in German, at my old notes and reflect a bit, I still relate to the young law student I was back then, angry, romantic, indignant, ever questioning. But when I read the entries on my Guatemala trip, I also see how inexperienced I was dealing with people from other cultures. The notes point to an inner conflict. I was on the sidelines, a mere observer, but wanted to be more than that. I was aware of my privileged situation and grappling with the distance between me and the struggle of those with whom I declared solidarity. My notes from these times are largely about me, and the situation was so alien to me. It wasn't until later in the life that I managed to stop conceiving of these encounters as journeys of political self-discovery and developed real empathy for people affected by injustices. In Germany, there were few people outside the Latin America's solidarity movement who were openly describing and criticizing the crimes being committed there and the complicity of the West. And so my work was certainly worthwhile, but at the time there wasn't anything more I could contribute. I did not yet have the requisite access to the legal community, to power, resources, or an audience. Nonetheless, it was a start and it spurred me on. Yeah, and to finish a little bit the reflections on Guatemala in my epilogue, while writing the book, I had the pleasure and the privilege to meet many of the protagonists. So also some of those whom I have been with in the times of the Guatemalan Human Rights Commission. And so I also meet Ana Antonia Reyes again, and reflect a little bit with her about that experience of 1990. In autumn 1990, as German reunification was underway, I was at the Guatemalan Human Rights Commission getting my first experience in human rights work. At the time, I found it hard to imagine that I could ever work in Europe and be useful to the human rights struggles as those people who were working in the commission to ensure they could one day to return to a democracy in their home country. In Guatemala, I meet again Ana Antonia Reyes, that was then in 2014, who was the head of the commission of the time. She was able to return after the peace agreement in 1996 and continue the academic career she had to abandon while in exile. Now she's teaching at the university and working for the state human rights body, once notorious for its proximity to the regime. It's a moving encounter with Ana Antonia. We compare notes on what has happened over the past 25 years, and we see we've traveled somewhat parallel path. Former dictator Rios Montt, who remained firmly in power in 1990, was since convicted of genocide. Even in Guatemala, things have changed, and then again, not so much. Indigenous politicians in the Guatemalan highlands are facing harassment and threats for organizing opposition to mining and infrastructure projects. Yet the fact that it's possible to take action within a global network in the fight for human rights and thus ensure that ever fewer crimes remain invisible, that's perhaps our greatest success. Going back to my own way into this, you asked me to read a little bit about the Argentinian experiences. That was, I said it in the introduction, back in 1998, 99, actually, before the Pinochet president. So this was also true in the case of Nora Marx. In addition to a complaint brought by her mother, Ellen Marx, I find witness statements from those who had been arrested with Nora on that August day in 76. A meeting was due to take place in a workshop in a suburb in Buenos Aires. The police had monitored the house, waited until all arrived, arrested those who were present, and taking them to nearby police stations where they were tortured. Ellen had visited these very police stations a few days after Nora's disappearance without knowing that she was inside. Based on the testimonies in the file, I tracked down others who were arrested that day and interviewed them. The results are frustrating. None of them know why they survived, but Nora didn't. Because of Nora's Jewish heritage and her name, Marx, the Argentine armed forces not only saw themselves as carrying on the tradition of the Prussian army, but also looked favorably on the Wehrmacht and cultivated an aggressive anti-Semitism. I speak with human rights organizations. Many of them have their own archives, but we can't find any evidence to show that after being brought to the police station, Nora Marx ended up at another location, such as one of the secret torture centers. She maybe have been killed after just a few days in detention. I meet Jorge Horowitz, a walking archive of the human rights movement. He collects all the available information, including witness statements from former detainees, to reconstruct the topography of the hundreds of detention centers strong all across the country and to piece together the stories of those held there. Jorge himself was held at the El Vesubio prison in the province of Buenos Aires, alongside Juan Miguel Tannhauser, whose case I was also handling. Jorge tells about Juan Miguel and a group of others were prepared for transfer, traslado. This indicated that a detainee would be murdered, shot and buried in a mass grave or drugged and thrown into the sea. I asked Jorge, why were you not transferred along with the others? I can sense the significance of this question. It implies that there may have been a rational logic behind the military's method of selection that the detainees could recognize. And it touches on the very sensitive issues for those who survived, the sense of guilt. Jorge gives an answer I can feel, an answer that stopped me in my tracks. He says that by that time the military had tortured him so much that he lay down in the corner of his cell unable to move. In moments like this, I can feel that I have overstepped an inner boundary. The more I ask, the more responsibility I bear. The more I learn, the more I become involved. We talk about the past, but the conversation creates a situation in the present, one that brings together both partners in the dialogue. I'm being entrusted with information and stories, and I must handle them carefully. One woman I speak to says that talking about it helps her to overcome the past, but only when there is openness on both sides. In 1999, having processed all the information, I submit criminal complaints. Just a few weeks later, it looks like the case might have already be brought to a close. There are legal complications, and I don't go into detail, but it was the time before the German International Crime Statute, parallel to the Rome ICC statute, was established. So very random legislation, and we tried to argue that the German Jewish victims have to be treated like Germans, even though they were stripped of their German citizenship by the Nazis in 1941. And that got a little bit complicated. When I hear that the prosecutors are planning to close the proceedings, I draft a letter to my client, to Ellen Marx and her group of the German Jewish mothers. I try to break it to her as gently as possible that the case we had launched with such high hopes might be ended prematurely. I use terms like, don't be alarmed. It's possible. There is a chance that. It's a convoluted letter since I also don't want to dash all hopes completely. In response, I receive a memorable fax. It was a time that fax were even, sent. Ellen Marx writes, "Dear Sir," she keeps up this formal tone throughout. "Dear Sir, we are old and hardened fighters." She tells me I don't need to worry about her descending into hysterics, that I should just carry on working. She says that over the past 20 years, she's gotten used to defeat. The fax is an eye-opener and a very important moment for me. I realize that I've fallen victim to my own prejudices. I don't talk to my other clients, the pacifist who blocks the street or the environmentalist who climbs up power station smokestacks, the way I talk to these older ladies. These women have a wealth of experience greater than we can imagine in dealing with repression. The images of these patient, seemingly apolitical mothers, humble and close to despair in white headscarf, as they call on the regime to show mercy, was a powerful political weapon. In this way, they had stood up to the dictatorship during its most violent phase, an act of defiance that had cost some of them their lives. The fax from Ellen Marx shames me. I should have known better, particularly with her, someone who has lost so many people and who's one of the strongest and most intelligent women I have met. So she's a German, Berlin Jewish woman whose parents were smart enough to send her as a teenager on the journey to Latin America in 1938, nearly in the very last moment. And her whole family was killed by the Germans. And she not only survived that, but found energy and fight spirit in Argentina. And then her daughter got disappeared by the Argentinian military dictatorship. So I realize that there are some things that must be done regardless of their chances of success. Doing everything possible to uncover the truth and achieve justice on behalf of the mothers of the disappeared is one of those duties. It doesn't matter what judges, prosecutors, or other lawyers might think of me. I learn that humility is not a bad trait, especially when as with the mothers, it goes hand in hand with persistence and a fighting spirit. And in continuation of this Argentinian story, another small part. A couple of years later, as many of you know, there were a lot of cases being brought in European countries, such as in Germany, which I was part of, in France, in Italy, and of course also in Spain. From 2006 on, Argentina reopened the investigations and trials against the military dictatorship and abolished the amnesty laws. And so one of the biggest waves of national prosecution of international crimes began. I describe a short episode of that. It's a pity that Ellen Marx and many other mothers of the disappeared are not around to see history being made in Argentina. On December 11, 2009, the trial begins in Buenos Aires against 24 senior officers for crimes committed at the torture center at ESMA. Amongst the accused are men who subjected my clients, Adriana Marcos and Bettina Ehrenhaus, whose stories I describe earlier in the book, to such misery. I know the faces and the stories of those being led into the packed courtroom, partly from Adriana's descriptions. Jorge Acosta, the tiger, Alfredo Astiz, the blonde angel of death, and Miguel Carvalho. This hearing is the last step in the long process that we have been part for so many years. It's a result of a huge amount of preparatory work. After 1990, when the newly reunited German state thought to investigate crimes in the former East, they set up a special prosecution authority with several thousand staff working on the cases for many years. Here in Argentina, it was just a dozen investigators researching these old crimes. Once again, it shows the importance of the decades of patience and persistence on the part of the human rights movement, which are now in a position to assist with the criminal proceedings and take part as civil parties in these same proceedings. My friends in Argentina are pleased about the reopening of the proceedings. They have never been able to forget what happened then, but now many are reluctant to find the time and the energy to engage with the past. The journalist and author Horacio Verbitsky makes the point during one of our conversations. I have spent decades of my life writing about this. Now it's time for other, younger ones to do it. This is understandable, and it's also smart political strategy. The trials are being monitored by members of the Hijos, the organization of children of the disappeared. Many of the lawyers and journalists working on the cases are young. The work of addressing the crimes of the dictatorship has now passed to the next generation. It takes me a while to figure out how I feel about it. For 10 years, I've worked to ensure that these trials take place. I've made this story my own as far as such a thing is possible. Now the language of violence has been silent. It's time for the language of law. Here in Argentina, I'm witness to an exemplary model of criminal prosecution. And yet I take no joy in seeing the old man being brought into the courtroom in handcuffs. It was never a sense of hatred of individuals that spurred me on. I find it strange to see thousands of people gathering on the big avenida outside the courtroom to watch live on a big screen as the verdict is delivered in another big case a few days later. The charges relate to murders committed as part of crimes against humanity. Each guilty verdict is met with applause from the crowd. They whistle shrilly when someone is acquitted. I find this hard to understand. I get a better insight what's happening when I start talking to some activist at a party later that day. After a month of tension, the verdict comes as a great relief to so many of them. A lot of people had to give evidence during the trial. They were nervous and felt threatened. Some of them were the targets of explicit threats. The young helped the old to prepare the statements and accompanied them to the court. The court hallways were filled with tears, joy, and pain. This drama stretched on for many months and finally came to an end with a verdict. And importantly, they told their stories and they were believed. The legal system that had been so hostile to them in earlier times had now rejected the excuses and justification put forward by the military and their defense team and had seen fit to jail once powerful figures. It was all these emotions that started to spill out on the streets when the verdict was handed down. In spring 2007, our second attempt to initiate investigations against Donald Rumsfeld and others in Germany ends in failure. The German prosecutors see no link to Germany and consider it too difficult, if not impossible, to investigate US state crimes in Germany. They do not accept our central argument that public prosecutors of different countries have to work collaboratively when it comes to complex international crimes. We're more convinced than ever, in order to make any progress, there needs to be a way to gather evidence in one place, linked up with an investigation in a different place, and then bring charges, eventually even in a third jurisdiction. One action builds upon another. You have to start at some single point, even if for now it may not be possible to follow through with the case all the way to an end. When the Pinochet case was filed, no one could have foreseen that the ex-dictator would travel to the United Kingdom in a private capacity 2 years later. But the reason the arrest warrant could be issued at the right moment was that when he arrived in Europe, the groundwork had been laid in Spain and decades before in Chile, that there was already substantial documentation and witness testimony concerning the crimes. In spite of this renewed disappointment, We had worked on this project for 2 years. I don't doubt that it was the right thing to do. Since speaking with Alan Marx, I've let go the idea that our actions need to be successful in short term. We continue our work on the Rumsfeld cases and push the French public prosecutor to issue an arrest warrant when Rumsfeld visits Paris in 2007, but we have no luck. We plan a criminal complaint in Spain. We want to demonstrate how vital it is to hold powerful actors liable for their action. These ideas start to spread. Our project is received with great interest in other places where similar human rights violations have occurred. At this point, I'm still a partner at our law firm, but it's clear that over the years I've become increasingly removed from this work. As much as I love to be a criminal defense lawyer, I cannot imagine doing only this. My travels and the cases that arise from them have expanded my horizons and the dimensions of my legal work. Recently, the everyday lawyering, the almost daily court hearings, the meetings and briefs to be written have seemed ever less satisfying. Though important, all of those are standalone, unrelated cases. Defending individuals, especially the poor and the politically active against the state, sometimes overly vigorous powers of prosecution, is of course a form of human rights work. This is the conviction I have held since I started out as a defense lawyer, but more and more I see a broader picture with more and more complex problems. I want to participate in something that goes beyond the individual case. I want to be part of a political project.
Great. Well, thank you very much, Wolfgang, for this insight into your very powerful book. And I had the pleasure of already reading it a while ago in German and now to read it again in English. It's really good. And it really emphasizes the stories of those you accompanied in their struggle for justice, and gave us some insight into your journey as a human rights lawyer and as a lawyer. So maybe I first would like to ask Ben to tell us a bit more about how you became a lawyer, and specifically a human rights lawyer, and involved in these struggles.
Sure, and I'll be brief so that we can get into the conversation of the issues that Wolfgang's book raises. The first thing I think I should say is that human rights law is a term that is not commonly used in the United States to describe domestic public interest practice. If you had told me when I was a law student that I was going to be a human rights lawyer, specifically that I was going to be a human rights lawyer working on torture cases and extrajudicial executions, I would have said, how interesting. I'll be working in Central America or in Sudan. But as it happens, the grotesque radicalization of the national security state after 9/11 meant that I could do all of that work in a domestic US context. I went to work for the American Civil Liberties Union in August of 2001 with the plan that I was going to work in jails and prisons in the United States as what we would call a civil rights lawyer in the US context. I was in Los Angeles. It has the biggest jail system in the world still. And I had no expectation that I would be traveling around the world to follow my country's human rights abuses. 5 weeks after I began that job, the 9/11 attacks occurred. And from that moment, all of these issues that we had imagined had been resolved in our legal system half a century earlier were front and center again. Detention without trial, detention without judicial review, torture, completely unthinkable, kidnapping, or as they called it, extraordinary rendition. People being placed on no-fly lists so they couldn't get on a plane with no explanation or no kind of due process. And so all of that became my practice. Just to take a larger step back, I had wanted to be a lawyer, not because I think it's the most important way to engage with any of the issues that we're talking about, but because I thought it was a very interesting way to do that. I think you make, at some point, a decision about whether You want your professional life to be fundamentally about helping people or accumulating property, to be very blunt. And once you've made that decision on the side of people, the challenge is to find work that is stimulating and interesting. But I have no claim that any of the work or approaches that I've taken in particular are more successful, more important, more significant than any other approaches.
And I think the importance of having various approaches to those issues, which you mentioned, also really comes out in your book, that as lawyers we also need to be part of wider movements and need to look at other strategies. What are your lessons learned after so many years of doing this?
Yeah, I mean, I had the luck and the privilege to accompany the Argentina cases now for more than 20 years, and it was a successful series of cases. So that is still kind of, pushing me. I mean, I have experienced something that, that is already big enough for one professional life. And how did it come that the Argentinians were somehow successful, relatively successful, to challenge their dictatorial past? That is, I mean, difficult to find out when you sit here, but it's easier to find out when you are in Argentina, because there you see, especially when you see mobilizations on the street, you have tens, if not hundreds of thousands of people, but in the front line, it's always the mothers, the Madres de Plaza de Mayo. And so it was a very interesting experience also to see, and I partly described it in the parts I read. I mean, for us as, let's say, Western European, especially Berlin, activists and leftist lawyers, obviously, it's like the typical hero, the leftist hero is, or the street fighter in the demonstrations, or somebody who fights in a liberation struggle. But here you have the complete contrary. You have mothers, elderly women with who are not at all appearing as militant, and who show their militance over the years and their engagement over the years. And that was obviously also a turnaround for me, and from this kind of post-adolescent, attitude to judge, resistance or political resistance from the outside. And what I saw over the years, and it became even more obvious now, first of all, coming from Germany, it's very clear that, confronting this kind of crimes of the past, especially the German genocide, is a task for the whole society. So lawyers, the law and trials can play a role there, but it's definitely not the most important. Maybe the most important thing about the Auschwitz trial in the 60s in Frankfurt was not the trial itself, but some of the most spirited writers in Germany had observed this trial and wrote about it, and that made us, learn about the extermination of the European Jews, and not the trial itself. And so, having seen that, and having seen also in Argentina how different sectors of the society work together was a huge inspiration, because here people tend to think in boxes. Here are the lawyers, here are the artists, here are the sociologists, or whatever. And there they saw it as a common task. The lawyers developed intentionally or intuitively a toolbox where the national level was complemented by the inter-American level, by the universal jurisdiction cases in Europe, and finally it came together. The lawyering went together with social mobilization and also with arts, and the younger were marching side by side with the elder, and that was something really interesting. And so I still think that is a kind of a story that has to be told here, but unfortunately it's not really perceived here, because justice can only be made in a court in London, in Berlin, or in New York. That's the way how the legal community, or in Strasbourg, that's the way how the legal community here digests lawyering and trial outside of North America and outside of Europe. And I think that's a huge mistake.
That's true. And how do you see it in the US? I
Yeah.
mean, we already talked a little bit about the very tense
Well-
situation currently. What can we do to make sure that as lawyers we are part of a bigger movement?
So I am going to speak now from a U.S. context. I think the relationship between law and litigation and social and political movements is actually fairly complex. I often describe my job as working on those issues where politics has failed, where the workings of majoritarian politics have produced an outcome that is unacceptable. Right, so that's how I would define constitutional lawyering in the public interest sense. And so, for example, there is no political constituency for prisoners' rights in the United States or in most countries. There's no one who's going to organize a majority to say that governments need to spend more money for the care of prisoners, unless you have some absolute catastrophe. And so here, litigation actually plays an important political function. You can get a judge to order a government to properly fund services in a prison. And actually, we found over the years that the people who run the prisons who we sue are quietly grateful for the litigation because they're not going to get the resources that they need from elected officials, but the litigation can create a wedge and it can compensate for this failure of majoritarian rule. If you look at something like marriage equality in the United States, this is not something that politicians really wanted to vote on until courts essentially forced the issue by saying that as a matter of constitutional principle, these rights had to be extended, and that was part of changing public opinion on it. The reason why I say it's complex is that litigators have to be very mindful of not being too far ahead of the public, even though the point of litigation is to compensate for failures in social and political movements. Because if you bring these cases 10 or 15 years before the public is ready for them, and you win, there can be a very genuine backlash against it. The first marriage equality case to succeed in the United States was in 2004 in Massachusetts, and it might have reelected George Bush because of the politics that were created around that case. And the US Supreme Court didn't get there until 2016, 12 years later, when the country was more ready for it. So I think sort of understanding that litigation is a tool, and very often a blunt tool, in what has to be a broader social and political movement. Its role is to, again, step in where a majoritarian political system is going to produce a very harmful outcome. But the reason why I'm still comfortable in many contexts using the term strategic litigation is that we have to know not just what cases to bring, but when to bring them.
Absolutely. And I mean, I know you also think a lot about the term strategic litigation, and it also comes from a wider history. The term success without victory was coined 15 years ago by Jules Lobel from the Center for Constitutional Rights, who you also know. Where do you think is that headed, that discussion, and what makes it different in using litigation as a tool, as you say?
No, I think it's in a way it's a wrong description of what had happened. I mean, the litigation in the U.S. Based on the Alien Tort Claims Act, so that was started in 1980, and it was far away from being strategic. When you talk to the actors of that time, Peter Weiss and the Center for Constitutional Rights, it was more like having a good intuition, having a good feeling that from a position of less power and less resources than the opponent, still exploring a situation and having a good feeling that this might be an opportunity to overcome this powerlessness for a moment, at least for a moment. And so I think strategic litigation covers that. and it's for me, because of that, it's like an ex post description of something which might have been successful but was never meant as strategic litigation. And also it's in a way it kind of overestimates the role of the lawyers and the litigation organization, and it also kind of isolates the activity of the lawyers, which always have to be seen in conjunction with the political situation, which has always to be contextualized in a certain political situation. And therefore, I'm very skeptical.
Can I ask you though, because I'm skeptical of long arguments about terminology. So, but it seems important to you to use the term legal intervention rather than strategic litigation, and to me it seems not important.
Yeah, no, that's another discussion, but I think it's, first of all, it's important to question, our own paradigm of strategic litigation, because I think it's important to question our practice over the last 10, 15 years. And I mean, it's nice to say success without victory. I mean, you can basically talk every failure nicer than it is. And I think that's the wrong take. We have rather than kind of painting our own work in nice colors, we have to be very clear what can and what cannot be achieved with our work. And I think what we did also, because there was a certain boom of litigation, not only here in the UK and continental Europe, but also in other parts of the world, we get a serious amount of funding for all of this. We get public attention for it, and that raises expectations which we cannot fulfill. And I think that's a political mistake. And that's something, rather than to speak about terminology, I want to initiate a political discussion, because I think that this work is important and it can play a certain role, but it's another role than we ourselves talk about in our funding applications and in our press releases.
Can I ask him another question?
Of course,
I don't want to leave you out, but do you think that the universal jurisdiction cases got too far ahead of the public? I said before, you need to be ahead of the public, that's why you're litigating, but you can't be too far ahead or there can be a backlash.
One with Balthasar Gasson, the investigation judge who was in charge of the Pinochet arrest, and was later then suspended and basically kicked out of his job as a judge. And the other with Máximo Langer, an Argentinian legal scholar who wrote 3 incredible important articles to describe the practice of universal jurisdiction over the years. And Gasson kind of is the kind of figure you might have in mind. This is the typical Spanish judge who really thinks he is the most important person in the world, and in a way, such a character of judge is needed in this kind of work. I mean, obviously, it was important to have a social movement back in Argentina, and also a smaller movement in Chile. But it's also important to encounter these kind of judges. And I mean, it's always about, and I don't believe in this story, sometimes you are too much ahead of. I think this is about, always breaking the boundary of what we consider as possible or doable at this time. And therefore it was incredibly helpful to have someone like Gasson who stepped ahead and who was actually far beyond not only his own colleagues in Spain, but many of the European judges. The problem then was years later that he still insisted that it's enough to have him and some of the colleagues, and not having seen that that this kind of cases mobilized the opponents, mobilized very powerful opponents, and they were already about to abolish this practice. And I think that is then the mistake. I mean, it's very interesting to have this icebreaker or pioneer, persons. It may be lawyers, may be prosecutors or judges. But at some point, you must also build political coalitions. And that was not made, especially in Spain and in Belgium, where universal jurisdiction was on rise in the beginning of the 2000s. And then in both countries, there was a real backlash. And I think that is the experience we have to learn, that one successful case or series of cases or one successful practice then needs to be analyzed, and it cannot just be repeated. Whereas the human rights movement tend to repeat. Yeah, and okay, then we repeat the Pinochet case, and we write our funding applications, and yesterday it's Pinochet, tomorrow it's this person, tomorrow that, and not looking at the circumstances, not looking at the political situation. And the same in the US with the Alien Tort Claims Act cases. And I think that's then the wrong thing. But I think there's nothing wrong about to be beyond that what is thinkable today.
And I will just say, and then I'll relinquish my role as moderator, that the Rumsfeld cases, which you described as a failure before, did not succeed judicially, but I'm quite certain that Donald Rumsfeld does not leave the United States to travel to Europe, which is a kind of accountability. Is that success without victory? I don't know. It makes me feel a little bit better that he, although he hasn't been held legally accountable, is confined to the United States and too nervous to travel around the world.
It's definitely at least a symbol of what is happening. But I'm still quite curious, and I know we are also wanting to discuss this tomorrow in greater depth at the workshop. But what do you think do human rights organizations, do human rights lawyers need to change in their approach in order to take this political space better into account and to prepare for that?
I mean, a lot. We always declare ourselves, connected to social movements. We think it's important to work interdisciplinary, but we don't take our own work serious. And I think that's the first thing. Then the second thing is it might be helpful for some human rights activists, human rights organizations or movements to say that to declare themselves neutral, politically neutral. Obviously, it helps you in the Soviet Union of the 80s, or in China now, or in whatever country where calling yourself radical or whatever, declaring that you want to change society is really more dangerous. But I think for human rights organizations in Europe and in North America, it's important to understand that human rights is a political issue. And in order to enforce and to realize human rights, especially when it comes to economic and social rights, you need to change societies and you need to change the world economic system, and we need to spell that out. And whereas many of us in this community think that this is dangerous. It's dangerous to spell that out. It's dangerous to spell out that we have political motivation and political goals. And I think over the years, that doesn't bring us in a better position, because many people who are attracted by the fact that we can raise issues, we can address certain injustices, who observe our work find it stupid that we are arguing so apolitical and that we are blanking out the political situation. Whereas I would say these are our allies, and we need to work for them. And we need also to say, I mean, sometimes we have a good law, like in the torture cases, we have good law, we have the absolute prohibition of torture, but when it comes to economic and social rights, sometimes law is very bad. It's very, very bad. The law is part of the problem, and the law is confirming a complete justice, a complete unjust situation, and then we need to struggle for new and other laws and for new and other way to organize the world economic system, and that of course cannot be carried out by lawyers, because and so I think it's towards a more outspoken political attitude and to cooperation with others.
And how do you see it in the US? Is that a different feeling, or is it?
I agree with everything that Wolfgang just said. I think that when human rights lawyers say that they're not political, people laugh at them. So that the ones who insist on being not political are not even taken seriously by the people that they're trying to impress with that statement. I mean, I would love to live in a world where the Universal Declaration of Human Rights is not a political document, but in the world that we live in, it's a radical document. And if you really believe in a world that honors all of those commitments, then you are on the side of some kind of radical politics. And I also agree with something that Wolfgang said before about where law fits into, moving us from here to here. This is not an entirely related example, but we were just talking a minute ago before we came out here about how millions of people in the United States who should have been the political opposition spent the last 2 years in front of their televisions and computers waiting for a prosecutor to solve our political problems through an investigation, instead of building a real political opposition, even though we had seen enough examples of how you actually beat these kinds of authoritarian leaders. And it's not by having legal rescue, it's by having a real mobilized political opposition. I think we still have time to do that before 2020 in the United States, but a lot of time was wasted by people who thought that law was going to be the answer to their problems rather than politics.
Absolutely. I also want to address one of the questions which we asked ourselves for the Litigating Rights series as such, and that is always the difficult relationship we have as lawyers with those we represent as well, and how we deal with this relationship. And especially, I think, with these bigger strategic human rights cases, it's always already a question of how do we choose those who actually go and do a case, who chooses them, who broaches whom in a way, and how do we make sure that even if it's maybe only one claimant in a case or two, very few, but they are representative for a wider problem of a broader community. So how do we interact in that space? How do you make sure that it's really for everyone that the case is? Or can it do that, or is that not an option?
Yeah, I mean, again, that's a complex question because it also involves legal ethics. What does it mean to be a movement lawyer representing an actual human being in an attorney-client relationship? Because once a case begins, whatever your movement goals are, must be subordinated to your ethical obligations to whoever it is that you're actually representing in that case. And the best way to reduce those tensions is to be very clear up front what kind of lawyer you are when you are taking on these cases and taking on these clients. And I think most of us are. Most of us, when we represent clients in these cases, are extremely candid about what we think the likelihood of success is. In the United States, until last year, every single case we brought on behalf of a torture victim was dismissed without any adjudication of the law or the facts. We didn't get past any motions to dismiss on secrecy grounds, on immunity grounds. And there's a real danger that you are going to re-traumatize a torture victim by having the legal system do to him what the intelligence community has already done. So you need to work with those clients to make sure that they're actually committed to the same political project that you are, which is not only trying to resolve the case with a remedy for them, but trying to end the practice overall. And one other way to do that is to represent organizations as well as individuals where it's possible in these cases, so that you actually have as your client not just one victim or plaintiff, but a whole organization that represents the values. We sometimes represent ourselves, right? A lot of our cases are called ACLU versus Trump, or ACLU versus Sessions or Barr. Yeah.
Yeah, that's one answer. And I would add to that there is a lot of incredible, interesting literature being written in the last 10, 15 years about that. And I still think the strongest piece is Makar Mutwa's Savage's Victims and Saviors piece, where obviously the role of the saviors is reserved for us, the Western human rights people, and of course we have to overcome that. But I see also a tendency, we could continue to discuss that for hours, I see also a tendency to be too much, it's important to link our work to critical critical legal theory, and especially to post-colonial theory, but it's also too important to come to action. This is real time happening, and if we don't act, who would then act? And so therefore, we often act in a very contradictory way, and we often act in situations which are full of contradictions, and where you can only choose between two evils, and that we must be aware. It's a question of consciousness, and it's also a question of spelling that out and clarifying it, because what should not happen, and I see a huge tendency, we shouldn't be paralyzed by reading and discussing only theory. And but of course, also not overestimating, us as the practitioners, and it has to be balanced out, and I think this balance is sometimes in danger to be lost.
And we're also not the only actors, right? So what I saw often in my work in Colombia is also the immense power the corporations have, and they really want to play out, and from sort of buying leaders, trying to divide communities. So we're not the only players in the field, and I think also the question of what to do when communities become divided, either through the work of corporations themselves, or just because the proceedings take a long time and then maybe a settlement is being discussed, and the opinions just go in various ways. I think that this is quite a difficult moment as well for any court proceeding and litigation you do. Before we open, I do want to have one last question to you, Wolfgang, as well, because in your book I think you also beautifully describe the importance of art and human rights, and how art can also be a really important tool. So I just wanted to ask you a little bit about your proposals in that field before we then open to the public.
I'm not sure if this is about proposals. It's more like I think it's as necessary as it is to develop a very pragmatic attitude towards today's realities. We should also develop utopian visions, which is very difficult to do as a lawyer and with law. And therefore, I feel very inspired to combine arts and law, and because artists can draw connections between past and the present very easily, and can, no, not very easily, but maybe easier than us as the lawyers. So where it's difficult for us to squeeze the colonial past of a country in a 50 pages legal writ, the artist can do it. And it's also, of course, it's also about imagining another society, which is also difficult to deal with as a lawyer. Although we have the Universal Declaration of Human Rights, where some, as you said, very radical claims are part of. But so, but what I also argue against is to see art as ornament of our work. Like the funders asking us to visualize our reports and our work, and to see this growing number of exhibitions around our work, which are just like seen as ornament.
But at the same time, and I think you've been a model of this for me over the last 12 years, how do you do this work for your life without burning out? And one way to do that is to build a rich community of support. And we don't want that community to be only human rights lawyers. We want that to be a community of people who, using different means and methods, are also trying to bring us a different and better world. And I hope that you don't get the impression when you hear Wolfgang reading from that he doesn't have a very rich and rewarding life, because he does, and I do. And again, part of that is the community that we manage to build around the work.
Well, maybe before we close, I do want to ask you to maybe also say something about what you would recommend nowadays students, of some of them which are here as well, who are thinking about that kind of activism, what they should do, of course, besides going to ECCHR with a Bonavero Fellowship. But
No, I mean, I am old enough to be in that position, but I still deny to give recommendations. No, it's like everyone has to make his or her own experiences. But what I try to describe and then also pointed to this, it's like, I think it's important to follow your own intuition and also to believe in your own dreams. And that is something, actually, writing such a book is also incredibly enriching in this regard. I write diary, and so reading my diary from years ago is sometimes very crazy, because I found out that I thought or that I dreamed things that at the time when I wrote it were kind of impossible to think about, but later on became true. And so, of course, I'm a German and I'm a lawyer, so the driest ever, thinkable combination. For me, it was a big learning experience over the last years to argue more with categories like for myself, or to think more of categories like intuition or like dreams. And because actually I did it, but I couldn't speak about it because I was captured in my own, German lawyer's mindset. And I think that's important to find your own position as a human being, and then of course develop your lawyer's or your jurist's career.
Ben, any final thoughts?
Yeah, so I think the framing of this question that I like the least, and it's not the way you framed it, is what's the most important work you can do if you want to be a human rights activist, and it's all important work across the board. The best advice that I ever heard on this was from a professor who said that most of you are going to spend more time at work than at home with your families, waking hours of your life, if you have to work. And so it's a good idea to surround yourself with people you love in that work. And when I was a university student and academia seemed like a possibility, I had a great experience that cured me of that, which was writing an undergraduate thesis, which took a year, and I realized that if I pursued that route, I would be a complete fraud. I would cut every corner possible because I didn't want to be in that cubicle by myself surrounded by books. I wanted to be out with other people all day and save books for something else, which is pleasure, in evenings and other times. I didn't want to do what you need to do to be a principled scholar, which is to want to spend your day. But some of you will actually want to, get away from the noise of the crowd and retreat back into that cubicle. And you know what? Our movement needs scholars too, right? So it really is about finding out what you want to do most days. And even if you decide to be a public interest lawyer, if you're a criminal defense lawyer, you're in court almost every day. If you have a job like mine, you sit on the 17th floor of an office building near Wall Street. And most of your day is spent reading and writing and in meetings and maybe talking on the phone, but you're very rarely in court. So if you don't like that part of the practice of law, you wouldn't like my job at all. If you want the action or speaking to a jury or seeing clients every day, you'd want to practice in a different way. So, and the only way to know which of these things suit you best is to do many of them.
So yeah, I think that's a good message also for our students and for all of us to try out various things and to see what we're best at, and that everyone and every type of work serves very good purposes. So before thanking our fantastic speakers, I do want to remind everyone that we also have a drinks reception outside now, where you can also find Wolfgang's book, Law vs. Power. And now please do join me in thanking Wolfgang and Ben for this wonderful conversation.